Hey guys, and welcome to today's video. Today, I have a good one, or better yet, a good 3 videos to share with you. We're gonna start with the judge going off on a lady for not accepting any responsibility for her actions, and we're gonna end it with a sovereign citizen who hasn't paid rent in 18 months, but still thinks he's entitled to equity in the property. But before we begin, I'd like to tell you about today's sponsor, Ground News. Ground News is an app and a website that brings together news from across the globe and presents it in one place, like this story about a federal judge siding with Meta over training AI with copyrighted books. Ground News allows you to sort the stories you read by political affiliation, allowing you to get all sides of the story. They also have this nice little feature that shows just how factual each source is. With this meta story, 94% of the sources are factual, with 49 of the 113 sources being center in their political affiliation. Speaking of political affiliation, Ground News has another cool feature called Blind Spot, which shows you articles that you may have missed due to only one side or the other side reporting on it. Like this story about the launch of Trump Mobile, which had 64% coverage on the left, 36% in the center, and absolutely no one covered it on the right. Now, I've been using Ground.News as pretty much my sole source for non-biased geopolitical news coverage. So go to Ground.News/Team Skeptic and subscribe through my link for 40% off the Vantage plan, which is what I use for my unlimited access. So click the link in the description or scan the QR code on screen for 40% off. Thank you, Ground News, for sponsoring this video. So let's begin.
Ms. Conley, can you start your video and unmute yourself, please? Calling the case number of SP4519123. This is the state of Michigan versus Mina Jenna Conley. Your appearance, please. That means tell me your name, ma'am.
Manaya Janae Conley.
Okay, and this is the date and time set for an informal hearing. It was set for 9:31. It's now 9:49. The officer has failed to appear. Therefore, this matter will be dismissed without prejudice. Any objection?
No.
Okay, but before that, ma'am, it's just not always going to be that easy because I would like to note 2 things. You're driving at a disgusting rate in a construction zone. You are putting your life and that of construction workers in danger, driving your car in such a manner. Okay? When I read this remark that says you are going 81 in a construction zone, that sends me. Okay? There is no reason in life, and you are not that important, for you to be driving so recklessly and selfishly on the road. And then I look at the ticket, and the trooper gave you a deal and wrote you a ticket for 5 over, which was a gift, right?
Right.
Because 81 in a construction zone, certainly if I do the math, is not 5 miles over the speed limit. And instead of taking responsibility for that and taking the loss and taking the break from the officer, you requested an informal hearing on it. And the break for you today is the trooper did not appear, so the ticket will be dismissed. But all that shows me, the court, is the type of person and driver you are. That you would drive in a construction zone where there are workers. Don't roll your eyes at me. Don't roll your eyes at me. And get a break at the road from the trooper. And instead of being gracious and responsible, you pushed for even more consideration. And you get that break today on a technicality because the trooper didn't appear. But you better think long and hard about yourself. If you roll your eyes again, I'm going to set this for another hearing.
I'm looking up. I'm looking in the background, never roll
Okay,
my
well, I would like you to look at me. There's no reason to be looking up.
Okay.
Show some respect and stop being such a selfish driver. And if you can't handle the responsibility of driving and the workers on the road, do everyone a favor and hang up the keys. Those men and women working out there are risking their lives. And the fact that you got such a break on the road and pushed it for a hearing today shows me that you think there are no consequences to your actions and you should just be excused for your selfish behavior. Learn that you exist with other people in this community and you are not important. You are not important enough to be driving and disregarding the other people and workers on the road. It is not about you. Slow down, be aware, and if you cannot be responsible enough, then don't drive because it's a privilege. Are we clear?
Yes.
Okay, you may leave the Zoom.
Now that we're done with that corrective ass chewing, let's head to Michigan, where we have a defendant who's facing a bond violation and a new felony charge. Now, he initially gets a bond for this new charge, but then he crashes out and instantly his bond is increased.
Thank you and welcome back. So we're going to begin in case number 25-4703FY. Mr. Ullman is appearing for arraignment in the underlying charges. He had one failure to appear, but we had renoticed that, so he's not facing any issues with regard to a failure to appear for the arraignment in this case, just the bond violation issues.
Okay.
And arraignment in the underlying charges. So Ms. Ferrara-Wilbur, did you have opportunity to review the allegations on the felony complaint, nature of the offense, possible maximum penalties, as well as the issues with regard to the bond violations with Mr. Ullman?
Yes, thank you, Magistrate. We did have the opportunity to review the complaint and the alleged bond violations, as well as Mr. Ulam's rights in this matter. In regards to the underlying charges, Mr. Ulam waives a formal reading, pleads not guilty, and requests court-appointed counsel. In regards to the bond violation, he also waives a formal reading, pleads not guilty, and requests that it's set for a hearing with counsel.
So I will appoint an attorney for you. I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning, and if you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. Ms. Ferrara-Wilbur, is there information you'd like me to know regarding bond?
Yes, thank you, Magistrate. In this matter, we would request that the bond is reinstated. On May 28th, it was set at $25,000, 10%. As Mr. Ulam stated, he does part-time handyman work. He's currently homeless and has no access to funds for a bond, but he has taken steps to obtain a mailing address and has access to a phone to maintain contact with the court and counsel in this matter. Thank you.
Well, at one point, he had posted the bond through bonding agency. So he had been out, and thus the reason for the allegations on the bond violation. And with regard to that, Mr. Ulam, I am going to remand you to jail until the time of that hearing. So the bond that you did have is gone. You are no longer on bond. You'll be remanded again until the time of the hearing. We'll get that scheduled as quickly as possible. You should hear from your court-appointed attorney by the end of next week, and we'll make sure that the hearing is expedited.
Alright, so for his bond violation, he lost a $25,000 10% bond, which is $2,500 for picking up a new felony charge, and he'll be held without a bond until he has his next hearing. Now let's see how high his bond is going to be for the new charges he picked up, and then let's see how high they raise it after he flips out.
We'll move on to case number 25-4779SM. And Ms. Ferrara-Wilbur, you had opportunity to review the allegations in this complaint, nature of the offense, and possible maximum penalties with Mr. Ulam as well.
Yes, that's correct. We did have the opportunity to review the complaint as well as his rights in this matter. At this time, Mr. Ulam waives a formal reading, pleads not guilty, and requests court-appointed counsel.
Based on the information that you've provided, I will appoint an attorney for you in this case as well. The next step in the process is a pre-trial conference. In this case, the pre-trial conference would be scheduled for July 15th. It would be at 9:30 a.m. And again, this for our Wilbur information regarding bond.
Thank you, Magistrate. Based on the remand in the other matter, we would request a low cash bond in this matter.
So your bond in this case is going to be a $10,000, 10% bond. Conditions on this bond are that you may not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You'll provide a list of your current prescriptions to the district court clerk. You will submit to discretionary PBTs and discretionary urine screens whenever requested by a police officer or any court personnel, so you may not refuse. You would have an immediate urine screen and twice, we'll say 8 times per month, urine screens hereafter. You'll have no contact in any manner whatsoever with Darcy. Means no phone calls, no messages through other people, no mail. You may not text message nor through any social network have any contact with her. You will stay 500 yards or more away from her. You may not be at any address that she is or may be. Specifically, you may not return to 811 Linwood Lane. You may not use nor possess any.
No, Mr. Ulam. No, Mr. Ulam. No,
what address?
Mr.
What
Ulam.
address? What address? I'm just confused. I just wanted to repeat I want to understand what the address was. What was the address?
The allegations in this complaint allege that it was at the residence at 811 Linwood Lane, but you can't be at any address that Darcy Robinson is or may be. You may not be within 500 yards of her.
I get it. I understand. No, I get it. I get it. I just want to clarify that I can't go to my home. I can't go to my house. I get it.
Mr. Ulam.
I'm homeless and I can't go to my house. Thank you. That's good. Thank you. Just making it clear that I'm not allowed to go to my home. Thank you very much.
You may not use or possess any weapons of any sort. You'll have no threatening, intimidating.
I know what the last ones were. Thanks a lot. What are you talking about? You took away from my phone. Hey, tell Darcy Robinson not to bomb me out again too. She bombed me out last time. Tell her not to bomb me out. Hey, come on.
So the words that I'm speaking about the no contact are in effect immediately, Mr. Ulam, and it's going to be a $25,000, 10%. Okay.
So he had a $10,000 10% bond and immediately had that raised to a $25,000 10% bond when he decided to let his inner dipshit out. Now we head to our third and final hearing of the day, where we have a sovereign citizen who thinks he can just live rent-free for 18 months by just discharging his previous debt.
All right, parties. I'm gonna figure out, and then we'll determine whether or not how we're gonna proceed. How we're gonna continue on. So I need both of you to unmute for me.
Yes, sir.
All right. Both of you raise your right hand for me. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
I do.
So let me first get a little bit of basic information. So Trust Property Services, do you guys have is this a commercial or residential?
This is a residential property.
All right, great. And when was the lease entered into?
March 25th, 2019.
Okay, when was it last renewed?
It was renewed on, it was signed on March the 9th, 2022.
Okay, and has it just been renewing every month since then?
Yes,
I mean,
sir.
every year on the other.
Yeah. Every,
okay. All right. And so technically renewed again on March 2025, but I understand that there's allegations of default before then. So how much is monthly rent?
$1,750.
Okay. Is there a late fee? If so, how much?
There is a late fee, Your Honor. The lost discount is $100, and Then there is a $10 per day additional rent, but I understand you have it capped at 10%.
Yeah, so we can do it at 175, which would be the most. When's the last time the tenant paid rent from any source?
That was on the ledger there. It was February 25th, 2022.
It's the last time he paid any rent?
Excuse me. No, sorry. That was when he started paying rent again. So previously he got behind significantly and the county stepped in and
Objection,
paid
Your Honor.
Oh, okay, well, he can tell me what he wants to say. Overruled. Continue.
Okay.
Okay.
And March 25th, 2023 was the last time rent was paid. So we began accruing rent at April 25th, 2023.
Okay, well, your complaint doesn't ask for all of that. It says that it is from December 25th, 2024 through March 2025. So explain that to me.
I did not file it myself. My assistant has been in the hospital 4 times and some weeks at a time. So I'm not sure what was filed.
Well, that's a concern because you're pursuing this. And you've got that this was filed back on, this was filed April 8th or April 18th. So this is well after that. Well, for an opportunity for you guys to make any additional determinations. I just want to make sure we have some clear numbers because the numbers that you're asking for in the complaint that was past due in April of $10,000, that was for rent through March.
Could you state, I'm sorry, sir, could you state that amount again? The thing went in and out.
Past due rent of $7,000, and that's for the months of December 25th through March 25th, 2025.
Yes, sir.
Okay, so I just want to make sure that you're aware of that. I understand that you're the agent, but okay, so he hasn't paid rent, at least according to the complaint since then, and you guys have not received any monies since December or since November at all, or at least in some.
That's correct, Your Honor. Not that I'm aware of.
Okay. All right. Well, just hold tight. Let me speak to Mr. Stevenson. So, Mr.
Yes, sir.
Stevenson,
What's going on?
when did the initial lease get signed? You recall?
Yes, sir. It was signed probably in 2019 or 2020.
Okay. When's the last time you signed a lease?
The last lease I signed was probably in 2022.
Okay.
I would like to say that I'm perfectly fine with answering all your questions, Judge. Nothing. I've filed a lot of evidence in this case showing that they have not done their due diligence whatsoever in this proceeding, which you've already recognized to a degree with their misnumbering of their own numbers. But I don't. I'm challenging the jurisdiction of the court. I don't believe this belongs in this court. I reserve all my rights, and I do not consent to administrative process and without equity, according to Article 3, oversight.
Well, I hate to be the one to piss in your paint chips, but this isn't a federal matter, so there won't be any Article 3 courts involved, nor will they have any oversight over your matters in the lower state courts. And while we're at it, the jurisdiction has been met by the facts of the complaint, and your consent is not needed. You haven't paid rent in 18 months, and the people who own the property want all the residing bleach drinkers to leave.
And so with due process under law, because I have a lot of evidence showing that I did my due process and did not receive that from them. Basically, that $7,000, he's saying that they just submitted a ledger to you guys saying that $65,000 is owed. And saying
I haven't seen that ledger.
But
so
he just said it in mediation. I'm not assuming.
So just hold tight.
Yes, sir. I'm just saying I got a lot of stuff, and it's a real case.
And then we, if need be, I can get into all of that because right now,
yes, sir.
One, what you discussed in mediation, I'm not aware of, right?
Yes, sir.
So I all of that. That's why I like to ask my questions. And
yes,
then
sir. I just wanted to make sure I got on record that I do challenge that we should even be in this court.
And I would say, if that's the case, did you file a?
I will.
But you haven't. So you have not sought to have the case removed to federal court, have you?
Not the federal yet. I was trying to get it removed just to Superior.
Okay. And under what basis?
Under the basis of equity. This is a rent-to-own case. This is not a normal tenant-landlord situation.
I would pause you because I'm very familiar with that. And if it's a rent to own situation, those generally are still considered contracts. You may have a lease, otherwise. And so, just before we
Oh,
get
I
into
got
that,
you. Okay.
because I've been doing this a little while. So,
I'm with you. I'm with
all
you.
right. So tell me, is rent 1750?
Your Honor, I'm not aware of what the rent is currently.
Well, you told me that you signed a contract back in
The
2022.
contract that I signed, the rent was not. If you review
Oh,
the
how much
contract,
is it? How much is
the
it?
rent that I signed at the time the contract was $14.50.
Okay, 1450.
It was $14.50.
Just getting information.
Yes, sir.
Okay.
I'm with you.
Did you submit your last contract online? Did you submit it as part of your evidence?
The contract, no, neither one of us submitted the last contract signed. I can't produce it, but I did not submit the last.
So hold on. Let me do my job. Okay.
My bad.
So you're saying the last rent is $14.50. Was there a late fee associated with that $14.50?
I believe so.
Okay. And let's just say for giggles, because we only gonna give them 10%, there was $145. Right. So tell me this. When is the last time you paid rent? Or anybody on your behalf?
I believe the last time that I paid rent would have been in the year of 2023, December of 2023 or so.
So from December 2023 to June 2025, you haven't paid any rent. It might be just time for you to pack up your crayons and eat them somewhere else.
Okay. And so, just to kind of get some clarity, December of 2023, that means all of 2024. And now we're moving into 4 full months of 25. And then if I were to give a writ, right, you would have 7 days. I understand you saying you ain't got no jurisdiction, all that stuff. I just want to understand what I'm working with. So it essentially would have been 16 months plus 13 days. Now, that's not what they're asking for.
Correct.
But you're saying you haven't paid rent at least for about 16 months.
Correct.
Okay. And is there any basis of why you've not paid rent for 16 months?
Yes, sir. They have some funny accounting. And so I submitted in accordance with UCC and all other statutes and legal statutes. I submitted a request for accounting, a full request for accounting, which I have a right to do. I submitted it under certified mail to the registered agent's address per the law. The registered agent received the first letter. I have all received, everything's in front of you in the submitted stuff. I submitted a document requesting a formal request, asking and saying that I would pay whatever was needed as long as they produced actual documents, especially because they're filed under a trust. So they're supposed to complete certain things as a part of their business model of how he's even running his business. And so I asked for that to be produced, and I would pay. The first one came to them, they received it, then they closed it back up, taped it up, and they rejected it. I sent two more. One of them I sent notarized, which is the big envelope you have. I sent the notarized copy. You also have a copy of what I asked and requested from them under the law. They ignored them 3 times. Then didn't ask for any rent for a year, Your Honor. And then when they did send me a notice to pay or quit, it was for $6,500, and now the $7,000, which is what you're looking at.
Okay, so let me pause. Let me pause because there's a couple things going on, and I don't know. You may not like what I'm thinking, but I'm just. You got 16 months past.
No, I wasn't at the time, Your Honor. I wasn't at the time.
I got it, but now 16 months past.
Yes, now.
They're asking for 7. When did they demand 65?
Today.
Okay, so did you get any notices about this hearing, or about this action before?
No, he said all this
it was filed
mediation.
against
He submitted new documentation today in mediation. He said he submitted it today and that y'all received it in court for $65,000. I have no knowledge of that.
Okay, well, pause. This is an important thing. It's important. I saw your defenses that you raised. Mr. Brown, can you tell me when or send Mr. Stevenson a demand of possession?
When was it sent to him? There was a pay or quit notice, and I do not know at that when that was sent to him, but I might be able to find it in the file.
That's going to be huge.
Okay. I believe the pay or quit was very recent. I believe it was last month.
Last month when?
Let me see. I have this payer quit. Oh, here's one from July of 2022. Here's
That's
one
irrelevant.
from July from 2021.
Let me see something from 25.
All right.
I have it, Your Honor. It's 3/15/2025.
3/15/2025.
Yes.
Okay. And what did it
Thank
say?
It said undisconnected rental rate, $1,750. Rent from January to March, $5,250. Additional daily rents, $10 per day at 92 days, $920. Recovery, $75. Existing unpaid balance, $321. Total due, 3/20/25, 6566.00.
Okay, so how much is that? Tell me how much they're saying is due.
$6,566, Your Honor.
Okay, and then when you got that, what did you do?
I filed with them a failure to contract, a no contract notice, and I refiled with them the notice I filed for them to give me proper accounting with the certified notary from the year before that I tried to file to them that they rejected because he's using a PO box as a registered.
Are you alleging that you paid too much money to them?
I'm alleging that I have equity in this home and that the stated amount that they
Okay.
are saying,
False.
the stated.
Well, you had equity in that home. Let's just say that everything you've stated so far is true. If you were on a rent-to-own contract and you didn't pay your rent on time, then they probably had a provision that any default in your rental agreement would be grounds to terminate your rent-to-own contract. In other words, any agreed upon equity that you may have paid in the past is now lost due to your stupidity.
I get all right. Equity in this home. Neither one of you submitted a contract. So tell me what
I didn't file a complaint. I didn't file a complaint.
but you're having a defense that you have equity and
defense.
rights in this property, right? So
Because
it's
they
your
left me alone.
responsibility. So listen, it's your responsibility to put up all the necessary defenses to support you, right? And so what I'm saying is you're saying you have a special kind of lease. So tell me what parts of your lease, since I don't have the lease here with me, justifies it. Well, hold on.
Okay,
I guess
well.
Mr. Brown was gonna answer that. Do you,
Oh,
Mr.
well,
Brown,
I thought you was okay.
Okay. Do you?
I'm fine. I'm quiet, man. I ain't said nothing, man. I'm good. I thought you was talking to me, so I thought I was.
I was, and I'm sorry, but you were just going. I just want to know what part of the contract. How do you have it? You have a lease to own? Is that what you have?
It is a rent to own. It is a rent to own where you're only supposed to be in it 3 years, and then you either basically leave or you're in a ownership position. I have to do my own maintenance. There's no, that's not me. That's coming out from my side. There's no, they don't come do a bunch of maintenance. I have to fix my own back porch. I got to do, you know what I'm saying? So what I was asking for a year ago when they came to me saying, hey, you owe some money, I felt like the accounting was off. And so I asked to see the accountant. They refused to show the accountant. That's it.
All right, Mr. Brown.
Yes, sir.
A lease to own agreement.
I'm just looking back. It would have been long expired if there was one. I'm just looking back right now because we do have a rent to own opportunity, and we do help deserving families end up with home ownership regardless of credit or financial background. So we work that into our program, and we give people up to 3 years to buy. And so when he signed in 2019, that would have been expired by now. And I'm just looking back to see if he even did that.
I'm not going to further delay this. This is what I'm going to do. I'll be honest with you, Mr. Stevenson. The initial facts, and because of the history I have with these cases, I would argue that they would be entitled to a writ, particularly the amount that they're seeking is a lot less than what you would normally be paid but guess what I don't have? I don't have a contract. And you make an argument that you may very well be entitled, but I don't have it. And depending upon the language of that contract will really make a determination of how I proceed. And so I'm going to reset it for in person. I don't necessarily believe that there's a basis for it to be in superior court. Those issues based on the contract may reveal that that's not necessary, particularly if you're not alleging that you've paid all this time or have submitted to them a opportunity to purchase and they didn't accept it. That's a different. But just saying that you have a lease to own, but then you've defaulted on it and you're very well entitled somehow to some type of equity. You might be entitled in a separate action and maybe some of the improvements that you've made, but that may not prevent them from being able to get you evicted. And that's a fact. That's
Your Honor, can I ask a question?
Sure.
Okay, so the fact that I still have a UCC claim, 100%, they did not respond to my request for. I have a right to accounting. They blocked it. What about the
But
fact
that
that
may
they
not
also,
prevent me from dealing with possession. See, I think you misunderstand.
Oh no, I'm not saying. I get that. That's what this is dispossessory court. I get that's why I asked to have it removed to a higher court. What I'm
But
saying
you
is,
need to file that stuff. The
well,
Superior Court
I
is not
will
federal
file it
court.
because I don't want to be put through this administrative process, which this basically is, and it's just kind of a quick kind of will and deal thing. And he's got legitimate. I have legitimate things that I'm saying. I asked for accounting for debt, and then now for them to submit a debt of 65,000. So what you're telling me is we're going to come to meet you, and we're just going to discuss the 6,500 and not the $63,000 that they're trying to put on the ledger now.
Well, I'm going to be honest with you. If you ain't paid rent in a year and a half, that wouldn't necessarily sound like that's not reasonable.
But under the law,
now?
though, I have a right to nullify that debt, and they didn't request that debt.
No, that's not how that works. You don't have the right to enter into a rent-to-own contract, not pay on it for a year and a half, and then just wave your magic soft-hard wand to nullify and discharge your debt.
Listen to me.
All right,
I'm going to reset the case. You're not even going to have to worry about an appeal because I'm not going to do an order today. I'm going to reset the case, and someone's going to submit to me the copy of the contract, and then we can take a look.
Your
Mr.
Honor,
Brown.
I did submit the contract. If you'll look at the email that we did send both the contract and the extension.
Clark, can I? It's not in my file, or maybe it's in documents and not in exhibits. Hold tight. See that? All right.
It was sent to dispossessory seat court 2. Let me see here, so I can be correct. Dispossessory CT2. I can't see the full extension of the.
Clerk, do you have an email from Mr. Brown?
I'm looking. Sorry.
Thank you. It would have been from Judy Weaver, my assistant.
And Mr. Stevenson, just so you're aware, if you're alleging federal matters, that isn't necessarily a Superior Court issue. That's a federal court issue. So having it removed or transferred to Superior Court still wouldn't be the appropriate place. Just to
it may be a federal thing. I'm just saying that I asked for the accounting of all of this so that I could pay and do my due diligence. They failed to do that, and then didn't request any money for a year, and then they just showed up.
And Mr. Stevenson, while we're waiting to see whether or not that's the case, what due diligence were you trying to exercise in a rental agreement? Was it a situation where they weren't?
It was a situation where I did not agree with what they were saying was owed by me at the time. They were saying I owed more money than I agree with. So I filed a form saying, show me the full, because we've been in business, like he brought up, during COVID. And just for the record, I just lost my mother on Easter, right? So I'm sorry
about that, brother.
I'm just saying, because he was mentioning, he mentioned that the clerk who filed all this stuff improperly has been in and out of the hospital. I'd have been through with breast cancer for the last 3 years. What I'm saying is my due diligence was still done properly, and theirs was not. And I feel like the court has to honor the fact that you have to do business the proper way. And so that's my stance, is that I asked for them to do business properly. They did not do it properly. They did not say anything. They left me alone for a year. No mail, no correspondence, no nothing. And then show back up and requested $6,500 for the new year, not 2024.
All right, so the original one, this is 2019. It's a standard real estate rental agreement. I'm gonna share this thing with you.
No, I know it's a lot in there. It's so much to the bottom where they get into the rent to own stuff. You come to classes.
Hold up. I got you. Hold tight. All right. So at this time, can you see what I see?
Yes, sir.
All right. So I'm gonna scroll on down. You tell me what section is the rent to own.
Okay.
And either one of you guys go ahead and jump in and tell me.
No part of that agreement refers to rent to own.
This isn't the full.
Okay.
This isn't This doesn't have anything mentioned about the other part of the program that they have, which is the path to home ownership. That's it, also in the agreements.
All right. So there's a path home ownership
Path to
agreement.
home ownership is what it's called. It's not listed. They're not showing that in that document they submitted.
You want to know what the quickest path to home ownership is? Pay your fucking rent when it's due and leave your sovereign citizen arguments in a mental hospital where they belong.
All right, let's see another one. And then here goes the one for 2022.
Yes, sir.
Hold tight. All right, and this one says extension of standard real estate rental agreement. That's what it says. It says 1750 in 2022. Looks like these are your signatures here electronically.
Yes, sir. But this is not the full. This is not their full program, and he can tell you that.
All right, well, Mr. Brown, tell me all.
He told you that the program lasted for 3 years. He's saying he told you the program is a 3-year program. That's it. That's the truth. You can look it up online and look their system up.
Listen, Mr. Stevenson, stop. I'm not against you, but I'm going to find it out.
I don't think you are. I'm just telling you.
So, Mr. Brown, tell me, he's saying that there's another part of this agreement that's not there, that's different from this. So, is that the case?
When we do enter into an option to purchase, it is a 3-year term, and that would have begun in 2019. That would have expired in 2022. It was not extended.
Well, I don't know that because you have a 2022 extension of standard real estate agreement. Now, I don't know if that extends that other offer or not, or the other thing or not.
It does not. We have 2 different agreements. It's the rental agreement that lasts for a year, and then we have the option agreement that lasts for up to 3 years. Whenever someone pays on time and does what they're supposed to do, their option remains in place for that 3-year term. But it is only a 3-year term. It does expire. And he did not ask for an extension of the option. He did not do anything to purchase the property, as far as I'm aware. And so therefore, we did not extend the option to purchase. However, when someone remains in our property and they do not extend their option, we don't kick them out. We just give them the opportunity to continue to lease the property. And that's what this is.
Okay. All right, Mr. Stevenson, you say there is an addendum. He's not denying that there's an addendum.
Correct.
And so none of your, just let me be clear. According to the contract, it doesn't appear that any of your payments go towards any type of equity or down payment or anything of that nature, right? Or are you saying that a portion of your payments do?
The addendum, see, that's the thing. Yes, the addendum does say that. So I would have that question on accounting for the 3 years. My question on the accounting is simple. It was on the amount owed, and it was also on. So after 3 years, you're telling me I have the money that I've paid into this based off of the agreements I cannot have any of this back.
What amount of money are you saying that this?
However much money may be accrued. What I was saying was however much money may be accrued during the 3-year process. I was interested in that and finding out more about that and finding out about the actual counting of how much money they were saying I owed for a couple of payments. I had not missed. After 2022, 2023, I was paying my rent normally. It wasn't until 2024, basically, that all of this went down. And I asked them to give me proper accounting, and they refused to give me proper accounting. And they used.
So you just stopped paying. I just want to understand your thought process.
There's not enough huffable duster in this world to be able to understand their delusions, Judge. Believe me, I've tried.
Okay, no.
Because I'm looking.
Okay, I was going to answer you, sir. Okay, you want me to answer? You want me? I can answer.
Yes. No, please.
Okay. Based off of my understanding of my legal rights, I understood that if they do not produce, and from what I saw in the UCC, if they do not produce the accounting properly for the debt does not. They are basically forfeiting the debt. And so I was like, oh, then we good. Y'all don't want to take or receive my stuff.
But you don't have. I think that's the part that you're missing, and I just want to be clear. You don't like the debt that you may be. This isn't a mortgage. This isn't. And I understand you're saying you had an option to buy, and I guess I'm missing that. But ultimately, your option to buy might get eliminated because you have a rental agreement that essentially, when you default on that agreement, that almost extinguishes some of your rights. And so I'm really not trying to be difficult on my rent. But you did default, and you defaulted based on your own admission.
They have produced no accounting And this is why we definitely need to come in person. They
But
have
you've
produced no.
admitted to me under oath that you have not paid rent for 16 months. Did you
I have
not?
admitted that I have, but that's not the month rent that they're asking for, Your Honor, and that's not when they saying I defaulted, Your Honor.
It's up to them that they're going to ask. Asking for lesser rent isn't necessarily illegal or not appropriate. That's their decision. Now, if they were asking for more rent than you very well would be responsible for, that'd be a different situation.
Okay, hold on one second. Let me grab my paperwork.
Okay. So this is what I'm gonna do. I understand that you've made certain federal allegations regarding UCC, but the contract that you said was never 1750 is 1750.
Wait,
So
whoa. Which contract?
The contract I just shared with you says 1750.
Hold on. Let me go.
The
You
one
guys
that
still pull it up?
signed, give it a whole time.
In 2022? I didn't sign a contract for 1750 in 2022, Your Honor.
See, you don't seem to know what you're signing, which makes me concerned that you really don't know what you're arguing.
No, Your Honor, I do understand what I'm arguing. What I'm saying is the document that you're presenting is the one on the screen right now, correct? Can you go to the next? Can you go to the bottom page?
This is it. This is one page.
And that's saying, and the rent total on there is saying for 1750.
Yeah, let me see if I can. You don't see that in the right there in the second paragraph under position 2.
This is not a real document. That's impossible. The rent they send me now is for 1750, and the rent goes up every year. I would like to show proof that this is really a document that I signed and that this was not forged. Because the rent, I can show you.
It's electronically signed. What basis do you have?
Sent me a rental agreement for 1750. Hold on, let me check my files. Give me a second.
You don't need to check your files. The judge has the rental agreement on screen. And while I have the agreement blurred for privacy reasons, I'll go ahead and show you the provision in the lease that clearly shows his monthly rent to be $1,750 per month. And then we'll get to the judge's ruling.
Well, in Your Honor, I did initially tell you I was not aware of how much the rent was at this current time because they hadn't been
well, they did send you a demand of possession identified.
I did say that. I did clarify that to you originally. I said I was not aware of exactly. I said the last rent number that I remember signing with them was not 1750. So I did not remember signing that exact number.
You're saying your whole defense to this action of you being evicted is ultimately because they didn't respond to the accounting of your prior payments on an agreement that you have at ultimately become.
No, sir. What I'm saying is that my premise is, hold on, because it's going out. Hold on.
And I just want you to understand,
no, sir,
you didn't sign another rental agreement after March of 2023. And in fact, you had told me that you last paid in December of 2023, right? And then as a result, then it would just be
in December of 2023, correct?
It would have just been continuing on a month-to-month basis. After March of 2023, you didn't sign a new lease, so you would just be continuing on a month-to-month basis.
That we would be continuing on a month-to-month basis?
Because you didn't sign a new lease, and it says that the lease terminated.
They never sent, but they never. Okay, so this is the thing, and this is my whole premise. Is not that they just didn't tell me. What I'm saying is that, Your Honor, is that they have not done any due diligence. They did not send me a new contract in 2023 whatsoever. I don't know if they had a staff change or something went on. They never sent the contract to get redone. They did none of their own due diligence for 2 years. Then they showed up saying that I owed them a certain amount of money after I had been paying. So I asked for them to show me that I owed them this money. They dropped all contact with me, Your Honor. And then a year later showed up saying, oh, you owe us $6,500. And so I'm going, that,
all right. That's a problem.
That's my problem.
Okay, so let me ask Mr. Brown, why did you guys not try to collect rent? Why did it take you so long to start this eviction proceeding?
It's a great question, and I don't have the answer for you. I do know that Mr. Stevenson has not paid. I've gone back on the records, and he has not paid since that time that I stated. And on the ledger, and that's the amount that I'm going on right there, is that the last payment that we received was March 25th, 2023. That's the last payment that we've received.
Okay, and he's indicated that it was, well, that's not necessarily true because you indicated to me earlier that it was December 2020.
He did.
Yeah, December 2023. So I don't know how you can say the last record, but you're saying the last payment was December of 2023, which is also applicable with the fact that you were kept paying after the second lease was terminated. So you guys were at least continuing on your relationship then, based upon you paying whatever amounts after March of 2023. So this is what I'm going to do. I'm going to give a writ of possession for the 13th. This is a completely appealable order. You can appeal what I've got going on, but I understand that you said you had an ability to potentially buy the property. But at this juncture, you've been in default, and you've been in default for 16 months, and they're actually asking for far less than what you would normally have to owe under the fact that you haven't paid. Now, your UCC arguments, they're still applicable. Like you said, they don't have jurisdiction here, but that doesn't necessarily mean that I have to stop everything I'm doing and not proceed here, because the issue of possession, as well as the monies that are owed, are totally applicable. Your counterclaims effectively can be dismissed without prejudice, because again, I don't have the authority to rule on them anyway. But I don't think that based upon those arguments, that is going to ultimately prevent what's currently being presented, a default on rent, which is clearly just a rental agreement, as well as possession. I wanted to get resolved, Mr. Stevenson, but like I said, man, when you got 16 months past due and you can't show me contracts and you haven't shown me that you tried to buy the property.
Asking for 16 months, yeah. They're asking for 4 months of rent.
And that's what they're going to get. They're not going to get 16 months.
Okay, well, I appreciate your honesty, Your Honor, and I understand that this is what your court, how it goes. I got it.
Gotcha. Listen,
but I will be filing the appeal, and so we'll continue to dance.
You'll have 7 days from today, but bear with me. Let me
tomorrow.
And we will be amending.
Oh, that's not good. So for all my non-lawyers out there, let me explain what the agent for the plaintiff meant when he said,
and we will be amending.
You see, when he realized that the suit he filed was asking for a judgment based on only 4 months instead of the 18 months of unpaid rent, he said that to imply that he was going to be filing a motion to either amend the complaint under Rule 59E due to a miscalculation or oversight, or he could be filing under Rule 15B, which he could bring due to you admitting on the record that you last paid rent in December of 2023. And just to honor the rule of 3, they can also file under Rule 15D to amend the complaint to include any other months that you have stayed that they didn't originally calculate. In other words, you should probably avoid the appeal and hope they just settle with the judgment that they received today. Because if not, you and your equity are fucked. Alright guys, that's the end of the video. If there are any updates to any of these cases, you know I'll bring it directly to you. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.